Dear student aspirants, hello and welcome to this video lecture series on behalf of CLAT SATHEE. I am Dr. Animesh and I'm your criminal law instructor. And today we are going to begin with our fourth module that is about offenses against property, crime against property. And in the first lecture of that module, we are discussing about theft and misappropriation. Very important, very interesting crime against property. Moving on. Simple logic is that we live in a very what we call a civilized society. And in a civilized society, every human being has a right to own property. A person without property is a person without security. How we secure ourselves and how we ensure our continued survival is through property only. If you have property, the point why you own property is to ensure your constant survival. The world is a very cruel place. That's why we have provisions, property, so that we can ensure our survival and survival of our offspring, of our generations. That's why people tend to have that property. If your property is taken, that sense of security, that hope of survival is actually harmed. And that is why people take this right of property very seriously. Although right of property is not a fundamental right per se in Indian constitution, but it is a very strong legal right. Right to own property, have property is an expression of your existence. आपके पास संपत्ति है, कुछ भी प्रॉपर्टी है, हर व्यक्ति के पास, even smallest belongingness you will have, that is very important. The sense of property you can see even in a little child who has a doll. See how much he is attached to that doll, that if his doll is taken from that child, the child becomes restless, because that is one of the most important instincts that we have. Even for a little child, they are very infatuated with the things that they have, a blanket or a doll or something like that. That is the essence of human civilization. We are attached to property. And taking someone's property is considered a grave crime against them, creates fear, insecurity in their mind, and obviously the issue of survival is there. Your survival is threatened if your property is taken away from you. That's the point of this particular right to property and right to that criminalizing any offense against property. So now let's try to define property. Now property in the most rudimentary sense means anything that has value and that is capable of being owned, it can be considered as property. Property is something that has some utility, and that thing is capable of being owned. Let's talk about the first aspect. Has utility. Now, what things have utility? Obviously, what things does not have any utility? The things that are not quantifiable in terms of money are not considered property. So, if it is not quantifiable in money, it has no utility, it is not beneficial for you. Or if it is in abundance, like say you go to Antarctica, ice there in the form that is abundant is not property. इसी तरीके से suppose I am going to a desert and in that desert we have sand, lots, heaps and mountains of sand. So whether that sand will constitute property, the answer is no, because it has no utility. Somewhere else it might be a very important aspect. अगर आप समंदर के पास रहते हैं तो खारा पानी, the sea water, is not a property because it has no utility. It is in abundance. So if something does not have any value, then it cannot be considered as property. And the second aspect of the same point is something that is quantifiable in terms of money. If suppose like human emotions are not something that are capable of being owned, because you cannot, it is not something that is quantifiable. Then we have second element, that is it should be capable of being owned. A property is property if it is capable of being owned. Like many things might have utility, like obviously human being. You cannot own another human being. They might have utility, but they are not capable of being. Similarly, sun, moon, forests, sea, they are not something that does not constitute property because they are not capable of being owned. Now, the government actually decides what is capable of being owned and what is not. Like wildlife. Wildlife is also considered not a thing, something that is capable of being owned. There's no private ownership. You cannot own a lion. You cannot buy and sell something that is an endangered species or is a wildlife. So owning something, that the property must be capable of being owned. If these two essentials are fulfilled, we can say that a particular thing is what we call property. Property is first thing, it has some utility and it is capable of being owned, and obviously it should have some quantitative, it should have some monetary value. It has utility, monetary value, and it is capable of being owned, then we can say it is that is a property. Okay. Now, offences against property is generally categorized into several categories. Like we have, first importantly, we have theft, chori karna, obviously theft. Then we have misappropriation. Then we have breach of trust. Then we have robbery, dakaiti, stolen property, cheating, forgery. Then we have mischief, trespass. N number of category of offences are there, which we will discuss over a period of time. But as of now, first thing that we have to discuss is theft. It is the most simplest. It's the most rudimentary form of crime against property, that you steal something from. There are multiple terms that are used for theft, like larceny, like burglary, like stealing. But the clinical term, the legal term for that is what we call theft. Theft is the legal term used for stealing something. Okay. Now, theft has 5 essentials. In order to constitute theft, 5 essential conditions have to be fulfilled. Without these 5 essential conditions, we cannot say that somebody has committed theft. What constitutes theft? Number 1 is what we call, there's some movable property must be there. Now, property, there is classification of property. In law, we classify property into multiple categories. First classification is tangible and intangible property. Tangible property, obviously anything that you can see and touch, a land, a building, a mobile phone, a laptop, everything is tangible property. But at the same time, there is something what we call intangible property as well. And when we are talking about intangible property, we talk about intellectual property, goodwill. Intellectual property, if you don't remember, it's like copyright. Suppose I created something out of my mind. I composed a song. I have a right over that song. That song is not in physical form. Suppose I made a painting. Now that painting is more valuable than the ink and paper that is used in that painting. अगर मैंने एक पेंटिंग बनाई तो ऑब्वियसली वो कागज का कुछ कॉस्ट है, कुछ कॉस्ट उसमें इंक का होगा ऑब्वियसली, but the painting might be way more valuable than that, because there is something that we call intellectual property associated with it. Now, whatever, suppose this particular video lecture we are recording, it constitutes intellectual property. Obviously, the information that is contained in this particular video lecture is not something that you can see or touch, but then nonetheless it is property because it has some value. So, two types of property are tangible property and intangible property. Within tangible property, we have to differentiate between movable property and immovable property. Now, movable property's definition is very funny. If you'll ask me, I'll say anything that is not movable is immovable. So that way, immovable property is also very simple to define. Something that is not movable is immovable. But that is not true. That is not how it is. It says, actually, immovable property is defined, and whatever is not immovable is considered to be movable. Movable property, we will discuss, we'll understand later. So let's talk about immovable property first. The immovable property is First of all, land. The first type of immovable property is land. Okay? Land is obviously removable. Now somebody might argue, sir, earth is moving, so land is moving. So that we do not go into the physical or geographical aspect of it. We take the rudimentary understanding. Earth is, or the land that we have is immovable. Then the things, the buildings that are permanently attached to the land. What we say, things permanently attached, rooted or embedded in land are also considered movable property. Like to give you an example, this building, you are sitting in a building, I am sitting in a building. This building is permanently attached or embedded in earth. The answer is yes. If you see, suppose there is a construction going on, that in that construction, the first thing that they create is the base of that building. नींव जिसको कहते हैं हम. They create a base for that particular building and then they construct upwards. First they dig a hole, make a base, then they construct the building forward. So that the building will be considered embedded in earth. It's rooted in earth. You cannot simply place rocks over the over earth and consider it as a building. No, it has to be embedded in earth. That is why we call it a immovable property. That's what we call it a building or a structure. If a structure is there, it has to be embedded in earth to be called immovable property. That's why a food cart is not considered immovable, but a restaurant or a hotel is considered immovable because a building is immovable. A cart can be taken anywhere. That's how it works. Then, a very interesting aspect, that if the immovable property, if there is a tree is also considered an immovable property because a tree is rooted in earth. जो tree है, जो पेड़ है, that is also rooted in earth. It's not some placed on the earth randomly. It's rooted. First roots grow, then the plant grows. So that things that are embedded or rooted in earth are also considered immovable property. So first is land. Second is things are rooted or embedded in earth. Third, things that are permanently attached to things permanently attached to earth. Like I'll give you a simple example. Suppose land is there. On a land, a building is there. In that building, in that structure of which is made of cement and bricks, there are some things that are permanently attached to that building. Like let's say doors, like fan, like AC, or whatever we call as fixture. Ye term of bacho is a very important thing. Something that are fixture. Fixture is something that is permanently attached to a building so that the building can be used. Like you might have ACs in your house, that is fixture. But a light bulb itself is not a fixture, but the bulb holder is a fixture because that is permanently attached to the building. Similarly, a fan is considered permanently attached to the building. So doors, the windows, they are considered as permanently attached to the building. Things that are not permanently attached, that can be simply removed without any mechanical process, they are considered movable. Like fan is immovable, but a table fan is movable. As simple as that. So immovable property constitutes three things. Number one, land itself. Then things that are permanently attached to land. Then things that are permanently attached to things permanently attached to it. Okay, so like tree is movable, but at the same time, leaf on that tree that is permanently attached to the tree is also considered immovable. Now, a particular confusion might also come in your mind. And what can be that confusion? Is कि sir पंखा तो खुल जाता है. Obviously, you can take a screwdriver and open the fan and it will be removed. Similarly, a tree can be cut. जमीन से कट गया. So see, the logic is, it is not true to say that anything that is immovable cannot be made movable. See, if a particular thing is immovable because it is permanently attached to the earth, by using force or by mechanical process or by any process, that thing can be severed from earth. So after they will be severed or after they will be uprooted from the earth, then they will be considered as movable property. But till they are embedded, suppose a ghar hai, obviously if you call a JCB a bulldozer, that will simply brick by brick that will break that house, demolish that house, and entire thing can be taken away. Fine, that can be done. But till it is attached to the earth, it cannot be taken away. Means it cannot be subject matter of theft. Very important to understand. Till a property is embedded in the earth, permanently attached, that property cannot be subject matter of theft until it is removed from the earth. Like simple example, एक पेड़ जब तक जमीन में rooted है, till the tree is rooted in the earth, that particular tree is not capable of being stolen. But अगर आप उसको काट दे तो that it can be stolen easily. So suppose there is a house. That house cannot be stolen. But if you demolish that house, you can carry away all the bricks. If a fan is there, till it is attached to your roof, जब तक आपके घर की छत पर वो पंखा लगा है, that fan cannot be stolen. But the moment you sever it, the moment you simply use a screwdriver and take it out of that holder, in that case, then it can be considered as a movable property and then it can be stolen. पंखा खोलने फिर चोरी हो जाएगा. पर जब तक वो embedded है, till it is permanently attached, it cannot be considered as property, as a movable property, and thus it cannot be stolen. ठीक है, यहाँ बहुत important. So land, building, and fixture, three things are there which are immovable. Obviously, they are capable of being made movable, and if they are made movable by some mechanical process, in that case they will be considered movable. But till they are embedded, जब तक वो जमीन से जुड़े हुए, तब तक उनका थेफ्ट नहीं हो सकता. आप मेरे घर का पंखा बिना उसे खोले नहीं चुरा सकते. आप मेरे घर का दरवाजा अगर if you want to steal that door, you cannot do it without actually severing it from the earth. जहां पे रखा हुआ है वहीं पे आप उसे नहीं चुरा सकते. You will have to sever it from the earth. एक पेड़ है, till you cut that tree, till it is rooted in the earth, you cannot steal it. That is how it works. Movable property and immovable property, we have to understand the difference. Okay? You got some clarity. Okay, second part is the property should be moved in order to be stolen. The first thing, there has to be a movable property, and that movable property has to be taken, it has to move. If it is not moved, it does not move at the same place. If the property is kept, it is not theft. Okay? I'll give you an example. Suppose I saw that a chain fell from somebody's neck, a gold chain fell from somebody's neck, it broke or somehow, and it fell on the ground. I saw it happen. So what I did, I simply went there and I placed a newspaper on that chain so that the person whose chain it actually was, the owner of the chain, will not find it, will not observe it around him. So what I did, I placed कई बार लोग पैर रख देते हैं. Suppose somebody, किसी का पैसा गिरा, वो गए उस पर पैर रख दिए. You plant your feet over that. So if you do that, whether that particular act of concealing it or putting your feet or your newspaper on it, a jhola on it, whether that will constitute theft, the answer is no. The property has to be moved in order to constitute theft. Theft के लिए it has to be a movable property and it has to be moved. And only see, you cannot file an FIR if my house is stolen. There was a art movie, a very offbeat movie called Weldon Abba, in which Boman Irani is a very famous actor and one of my favorite actors. He's there in that movie. And in that movie, it is about that Kuan, Baudi is stolen. Baudi ki chori. That's a very interesting movie. If you find such some time, you can watch that. It's a light-hearted, nice movie. So that particular movie revolves around that fact that a particular well is stolen. So well cannot be stolen because it's a immovable property. And the property has to be moved in order to constitute theft. If the property is not moved, in that case, it will not constitute theft. Third thing is out of the possession. This is very important. For theft, the property must be taken out of the possession of someone who is holding the property currently. I'll explain it to you. What is possession? Possession is simply having the control over a particular property. Now, this possession is different from ownership. Ownership is different, possession is different. How it is different? See, you can own a property if you have legal right over it. Okay, if either you have created that property, or you have purchased that property, or you might have inherited the property. Generally, there are three ways in which you get property. It has been, if you have created the property, it has been transferred to you by someone. Either they might have given you as a gift, or you might have purchased it, or you might have inherited it from a dead person. There are three ways to get a property. That makes you the owner. But a property, it is very much possible that the particular property can be your property, but it is in the physical control of someone else. See, I presume everyone who is listening to this lecture is 18, 19, 17, 18, 19-year-old, class 12th boy or girl. See, every property that you have, everything that you have currently with you is actually not owned by you because you have not purchased it. It has been purchased by your parent or guardian. Everything that you own, you only possess it. Because in order to own it, you will have to, you create it, you buy it, or you inherit it. That's not the case. So generally, everything that you have is in your possession and not your ownership. So being in possession is a good thing. It's fine. You give your book to your friend, then you remain the owner of that book, but now the book is in possession of your friend. Possession simply means in control. It has two elements, possession. Number one is corpus possessoris, what we call, yani ki you must have physical control over that property. At the same time, you must have intention to hold that property. If you have physical control over a property and you have intention to hold that property, then the property will be considered to be in your possession. And if the property is in your possession, then the property can be taken out of your possession. And that is a very essential ingredient of theft. If the property is never taken out of my possession or physical control, in that case, there cannot be a case of theft. अगर प्रॉपर्टी जिसकी पोजेशन में थी, अगर उसी के पोजेशन में, like I'll give you an example. Suppose I just want to play a prank on my friend, so I took something that was in his one bag and I put it in some other bag of his, in some another bag of his. Now, with an intent he will search for it and it will be funny. Simply, आप किसी कोई चीज छिपा देते हैं. You took that property and you hid it in that person's house or that person's room only. That does not constitute theft because you have not taken the property out of the possession of that person. This is very important. Taking the property out of the possession. If you do not take the property out of the possession, that does not constitute theft. अच्छा, यहाँ पे there is very important distinction. See, possession need not be lawful. Means if a particular property is in the possession of someone, their possession can be legal or illegal for that matter. Means suppose somebody steals a property from you, then somebody steals that property from that thief. Whether both the acts are theft, the answer is yes. If I steal the property from a person who I know is a thief and this property belongs to someone else, that will constitute theft. Why so? Because even though that person is not the owner, he has physical control over that property and he has the intention to hold that physical control. Means he has intentionally he has that property. There is intent to hold that property. If I throw some property, suppose sabere you have something that is undesirable in your house. Suppose there is a broken chair in your house, and you throw it, you keep it outside your house, and now with an intention to discard it. Now somebody takes that particular broken chair from that place. Whether he has committed theft, answer is no, because that property has not been taken out of your possession, although it was just outside your residence. But still, when you kept that outside your house with an intent to discard it, you lost the possession, in the sense that you completely lost the intent to hold that property. So that property is already out of your possession. So somebody picks it up from the street, that is not considered as theft. That is not theft then. Okay. So it has to be out of possession. If the property is taken out of possession of someone, then that constitutes. So even if I have taken the property out of the possession of a thief, still that will constitute theft. And there is a very interesting all the time what we call a cult movie among those who follow Bollywood, that is Hera Pheri. Hera Pheri series, in which the central character Akshay Kumar and they all the trio, they make a plan to steal something from the house of a thief. They know that this person has stolen something, and now they go into the house of that thief to steal it. So even if you commit theft from the house of a thief, that still constitutes theft, because you are taking the property out of the possession of that thief. And the thief, although he is not the owner of the property, will still be considered to be in the possession of that property. Okay? Okay, acha, if somebody takes the property out of the possession of your servant, that is also considered to be that is still considered to be in the possession of the master only. Suppose there is a person who is your employee. Employee's possession is considered to be employer's possession. It's a little tricky, but I'll explain. It's very simple. Suppose there is a property with me, which suppose there is a laptop which the university has given me. I am employed at a university, so university has given me a laptop. Now I hold that laptop. The laptop is in my custody, but the possession of that laptop remains with the university because that the university has given it to me as an employee. So अगर employer की property अगर कोई employee के हाथ में है, तो the possession is still considered to be of the employer and not of the employee. So suppose a person who has been given a laptop from the company runs away with that laptop, he'll be prosecuted for theft. He cannot say, no, the laptop was already in my possession. No, company gave you that laptop while keeping the possession with them, because you had a what we call employer-employee relationship, master-servant relationship. So if the university has given me the laptop, although the laptop is in my control, or what we call it custody in legal terms, the laptop is in my custody, the possession remains with the university, because university and me and my university, we have a employer-employee relationship. This is very important. Suppose एक दुकान है, and the दुकान में suppose a particular cashier is there, and the cashier has cash. Who has the possession of over that cash? The cash is in the possession of the company, not the cashier. Bank mein, the whatever money is kept in the vault, that money is in the possession of bank or is in the possession of the manager who has keys to that vault. Obviously, it is in the possession of bank and not the manager. So that is the law of possession. The possession of the employee is considered to be the possession of employer. Okay. Fourth is without the consent. Obviously, it is needed that in theft, the person's consent should not be there. If I take the property out of the possession of someone with his consent, then obviously it is not theft. If I ask you permission that should I take your book and you said yes, then you have given consent, that is not theft. But the consent should be valid. In order for the consent to be valid, the consent must be taken without any what we call fear or misconception or fraud. It must be free from fear or fraud. Now there is a joke in which a person says, person is taken to court and he is asked whether, see, you have been charged with robbery. No, sir, मैंने robbery नहीं की. I have not committed robbery. I asked for this person's watch and he gave it to me. Just when he gave it to you? Well, when I showed him my gun, he gave it to me. So that is not a valid consent. Obviously, if you show the gun, anyone will give you their property. So the consent must be free from fear and misconception. If you have committed a fraud or you have committed a force, if there is a force, that is not considered consent. So if you take someone's property out of their possession without their valid consent, that constitutes theft. Now, consent obviously is a very important aspect, but the consent can be expressed or it can be implied as well. Now, how can consent can be implied? Obviously, if I asked you physically, actually verbally, that should I take your property, you said yes, then what we call express consent. Implied consent is there when there is a pre-existing relationship between two persons. If you have a roommate, or you obviously, if you are not in a hostel, if you're not in a hostel, then you must have family members. Now there is an implied covenant in the family that people can use the property of each other. Yani ki suppose I have spent a lot of time in my hostel of the National University. So my roommate and we didn't have any idea or the concept of separate property. Except some clothes, everything that was there in the room was for everyone. Even some other friends, we had this idea that they can come and they can take anything from which I have bought, which I have purchased, that is my property. There is nothing like my property and your property. In most of the boys' hostel, this idea is there. And they can use the property. Suppose I have kept food on my table, they'll say simply come and they'll eat that. And I cannot say theft because I do the same. Because of a pre-existing relationship, act which otherwise would have been theft will not be considered theft because there is something what we call implied consent. A husband's property a wife can use, a wife's property husband can use. That is what we call an implied relationship. Family members, close friends, associate, colleagues sometimes. Sometimes I forget the marker, so I go and I take simply the marker from my colleague's table. That's fine. That is an implied covenant. But obviously, I cannot take their mobile phone because there is a limit to the consent. And implied consent also, the common sense have to be applied. What properties are considered to be within the domain of the consent? Yes, what properties you can take, what properties of mine you can take, what property of yours I can take. So that is something that have to be kept in mind. So the nature of relationship, the court, if a matter comes, the court will adjudge that what would a ordinary prudent person would have reduced. If you are close friends, you are roommates, then even if somebody borrows your shirt, that's perfectly all right. That happens all the time. If it fits, then it's fine. There is a saying in our hostel, if it fits, it's fine. So without the idea of consent is obviously related to, it can be expressed, it can be implied. Then the mens rea, the mental element, dishonestly. Now, dishonestly means with an intention of causing wrongful gain or wrongful loss, or both of it. See, in order to constitute theft, there has to be an intention on the part of the accused to cause either wrongful gain to himself or wrongful loss to the other person, or both. But either one should be there. There has to be an intent of causing wrongful gain or wrongful loss. To give you a very simple example, point number one, I'll tell you. Suppose you have what we call a laptop bag. Now, we see HP, Lenovo laptop bags are almost same. So there are two laptop bags kept at a particular place. You take one which does not belong to you, thinking it to be yours. We all the time it happens. We take someone else's property thinking it to be ours. And there is what we call faux pas. We do that mistake as to the identity of property. So whether you have taken that property with an intention of causing wrongful gain or wrongful loss, the answer is no. You took it by mistake. In that case, it will not constitute theft. If the intent was not to cause wrongful loss to the person or not to enrich yourself illegally, in that case, it will not be considered theft. Why you are taking that property is very, very important. If I honestly believe that the property that I am taking is my own property, then it will not be considered dishonest. This is very important to understand. Dishonestly, there has to be an intent of causing wrongful gain or wrongful loss. If that is not the case, if your intent was not to cause wrongful loss to the person or not to cause wrongful gain to yourself, it will not constitute theft. If you have taken the property for safekeeping, there's no intention of wrongful gain or wrongful loss. Suppose you find someone's wallet and you keep it with yourself with an intent to restore it to the actual owner. आपको कोई सामान पड़ा हुआ मिलता है and you pick it up, and that happens in the university, any place, a school, there must be something called lost and found. So if your intention is to restore it to the actual owner by finding that actual owner, in that case it will be considered as, it will not be considered dishonest act, and thus a person will not be convicted of theft. So it has to be dishonest act with an intention of, even if you are taking your own property, there is an example in BNS in which there is a particular person who gives his watch to a watchmaker, to a person who repairs the watch, कि भाई आप इसको repair कर दो, ठीक है. So next day he goes to that particular place and he simply takes his watch and leaves. The shopkeeper was otherwise occupied in some other customers, or he was not at that point at the shop. So he sees that his watch is ready. He takes the watch and he goes away. Now the question is whether his action will be considered theft or not. The answer is yes. Although he took his own property, but because he didn't pay the shopkeeper he didn't compensate the shopkeeper, he didn't pay the price of repairing, in that case, it will be considered as dishonest act. That is a dishonest act without any doubt. But let's say somebody stole your property and you steal it back from that person. Whether you have committed theft, the answer is no. Why? Because the property is movable, you have moved it out of the possession without the consent. But whether your act is dishonest, the answer is no. Because there is no wrongful loss or gain to any person. that property actually belonged to me. So when I took that property back, there is no wrongful gain. At the same time, the property was not his. So the loss he faced is not a wrongful loss. अगर मैं किसी चोर से अपना सामान चुरा लूं, अगर किसी और का सामान था और मैंने चुरा लिया तो ऑब्वियसली मुझे क्या हो गया, wrongful gain हो गया. Although his loss is not wrongful, but my gain is wrongful. In that case, it will be considered to be a dishonest act and thus I will be prosecuted. So in order to cause wrongful gain or wrongful loss, there must be intent. Why you are taking that property? So all of these 5 elements are required to be proved in order to punish someone for theft. If any one element is not there, obviously movable property element to ho gayi or moves the property. But suppose if you have not taken the property out of the possession of someone, what you did, you found out that there's some valuable item in someone's house. So you hid that valuable item in his own house. Whether that will constitute theft, even if done dishonestly. If you have not taken it out of the possession, then it will not constitute theft. But if you hide it so in such a way that it cannot be found by the person, might constitute theft. Depends on the facts of the case of it. But if you took the property with the consent, but let's say you were dishonest, whether it will constitute theft? Answer is no. Like I'll give you an example. Suppose I go to someone and say कि भाई अपनी साइकिल आप दो मुझे 10 मिनट के लिए. I want your cycle or your bike for 10 minutes or so. But my intention is dishonest. In my heart, if that person were to give me his bike, I will run away with it, or I will go and I will sell that bike and will eat the money. Whether that act will be considered theft? Answer is no, because although my intention was dishonest, still I took the property with that person's consent. So in that case, it will not be considered theft. So I'm not saying it will not be a crime, but it will not be theft, because in theft, everything has to be fulfilled. Let's say I took someone's bag by mistake, means thinking it to be my own bag. When I took it, my intention was not dishonest. So obviously it cannot be theft. But suppose later I found that the things that are there in that bag are very valuable. उसमें बहुत सारा पैसा था, iPad था, and मेरी नीयत खराब हो गई. So in that case, whether it will constitute theft? Answer is no. Because when you are taking away the property, at that point of time, your intent will be material. उसमें आपका intent क्या था? That will matter. Later, what was your intention will not be material for prosecution of theft. Theft के लिए जब हम punish कर रहे हैं, तो all these 5 elements should be there simultaneously. If suppose one of the elements is missing, in that case, the person will not be punished for theft. But for what that person will be punished? चलिए आपको एक और एग्जांपल देता हूँ. Suppose I found a laptop on a train seat. On a train seat, I find a laptop which obviously belongs to someone. Someone forgot their laptop on their train seat and they have deboarded the train and they have went away. And you find that laptop. And you take that laptop and you start using it or you sell it to someone. Whether you have committed theft, answer is no. Why? You have not taken the property out of the possession of someone. The laptop was lying there. It was in no one's possession. So if you take the property which is in no one's possession, you find something on the street, then you take it for your own good. That will not constitute theft because you have not taken it out of the possession. Although your intent is dishonest, you have taken that laptop with an intent that you will sell it. Still, it will not be considered theft because you have not taken it out of the possession of someone. So all 5 elements should be mandatorily there. If even one element is missing, that will not constitute the theft. Okay. So if one of the element is missing, then what will happen? So we move on to next, that is criminal misappropriation. It simply says that if anybody takes any movable property of anyone, किसी की कोई movable property, he misappropriates or converts to his own use dishonestly. If you take someone's property which belongs to someone else, here the element of possession is not required. Suppose that person has given you the property and you convert it to your own use, you misappropriate it with dishonest intention, you have committed what? Criminal misappropriation. Things that do not constitute theft because one of the element is missing, they generally fall within the domain of criminal misappropriation. Like वो laptop वाला example, if I took that laptop from that train seat, it will constitute criminal misappropriation because it is a movable property, it was someone else's movable property, and I converted it to my own use, and my intention was dishonest, so it will be considered as criminal misappropriation. If you find something in the on the street, except money, see, money is a little exception because if somebody loses money, then they lose the money completely. In the sense, there is absolutely no way in which a money जो आपके जेब में नहीं है, पैसा रोड पे गिरा है, it is impossible you will be able to prove your ownership over that money. So if you lose money, cash, in that case, you lose the ownership of the cash as well, not the not only possession, but you lose the ownership of that cash money as well, because the moment you lose cash, there is absolutely no way you can prove that that is your money. In respect of all other properties, you can somehow prove, you'll have received, you'll have pictures, you can give a appropriate idea. If it's a wallet, definitely you'll ID card, kitne paise the, everything that can be used. But suppose आपकी जेब से 500 का नोट गिर गया, तो फिर जिसको मिला वो उसी का पैसा है. There is no misappropriation because that money belongs to no one. That money is lying on the street. So, but if it is a property whose owner can be traced and the person finds the property and converts or misappropriates to his own use, in that case, it will be considered misappropriation. Similarly, suppose somebody gave me his property for any purpose. I asked, bhai, I need your laptop for half an hour, 1 hour, 5 days, 10 days. I return it to you after you. And I misappropriated it or converted it to my own use. बेच दी मैंने उसका लैपटॉप, और in that case it will be considered misappropriation, although it will not be considered theft because I took the property with his consent and he gave me the possession. I did not take the property out of his possession without his consent, but rather he gave it to me. Then that constitutes misappropriation. Similarly, the example we took about mistaken bags. See, at the time of taking the bag, since my intention was not dishonest, I have not committed theft. But later, niyat kharab ho gayi mein, my intent became dishonest. Now I do not want to go to the owner of the bag and take an exchange. In that case, it will be considered to be a criminal misappropriation because dishonest intention and criminal misappropriation can come at any point of time. Suppose when I found that laptop, my intention was to return it to the original owner, but later my intention, it became evil. I became dishonest in my approach. Then the moment I convert it to my own use dishonestly, it will be considered to be an act of criminal misappropriation. This is very important. Theft के लिए बड़ा important 5 चीजें होनी चाहिए. It must be movable property, which is required here as well. Moves that property out of the consent, without the consent, out of the possession. In criminal misappropriation, all these things are not required. In criminal misappropriation, if simply property belongs to someone else, it's not about the possession, it's about the ownership. If somebody has the ownership of that property and you dishonestly convert it to your own use, in that case, misappropriate or convert your own use, yani you take the benefit out of that property which was not yours to take, in that case, you have committed criminal misappropriation, and thus you will be punished. The punishment for theft or misappropriation is similar, 3 years imprisonment, but these two offences are separate in their approach. Okay, so this much we have to understand. I hope you got some idea about theft or misappropriation. I'll see you in the next class with some more offenses against property. Thank you so much for being patient listeners. I'll see you in the next class.